finish up our section on valuing damages and the like, and I also think, if I remember right, we have a discussion on jury instructions that we have to have very quickly as well, right? Rule 51, instructions to the jury. Let's talk quickly about jury instructions. First of all, not that the form book is the end of the day, but the form book certainly isn't a bad place to begin your legal research. And there are form books downstairs with respect to jury instructions. It depends on the type of the case, obviously. Obviously, the instructions have to be adapted to the case. But what the instructions are the last word the jury hears from the judge with respect to what the law, the appropriate law is that's going to be used as they deliberate and resolve the case. So obviously, since they are the last words the jury hears, they're vitally important. And therefore, it's important and incumbent upon you to make sure that the jury gets the appropriate instructions. And it's important for you also to know what those instructions are going to be, because you need to tailor your evidentiary presentation around it, you need to tailor your opening statement around it, and you need to tailor your closing argument around what those instructions are. So obviously they become fundamentally important. They actually should be, and we never do it, and even I, as many times as I've done this little discussion, I still don't do it. We really should do and look at what our jury instructions will be when the client comes in the door. And by that, what I mean is we look at what the law is, we develop our research on negligence or whatever the topic is that the client has the problem with. But it's almost even more important, if we were to do our job right, that we should pull out the form books, look at the other information, say, well, 2 years from now, what is the judge going to be telling the jury is the last word on what the law is and what they consider in deciding whether this constitutes negligence or malpractice or whatever it is? Because everything should be geared to that objective as you think about your complaint, your discovery, and everything else. And I keep saying that's what you should do, with the recognition that I don't do it, but I should do it, and I think better lawyering would in fact do that. But what it really is the understanding of what the law is and how your evidence and your presentation needs to tie to that law. From a standpoint of how it works, normally the court will ask you to propose jury instructions. And both sides would oftentimes give their own versions to the court, and the court at some point will have a conference and then a discussion on which ones they intend to offer. And the procedure differs wildly as to how that actual process works. A lot of courts, certainly the federal courts, there tends to be a final pretrial conference about anywhere from 3 months to a month before the actual trial. The court at that conference oftentimes will, in addition to trying to see if it'll settle and how long the trial will take and all the rest of it, will talk about two important things. What questions there will be submitted to the jury, and then the second part of this is when we will know what the instructions are, and we hopefully may well know it at that final conference. And so usually beforehand, in order to get there, the court might ask you to propose jury instructions. Now, since they're the last word the jury hears, you have the ability to look for instructions that you want, that make it easiest for them to find the way you want. I'll just give you a simple example, and it's really simple, so it may oversimplify it as well. You all know that the standard of proof is a preponderance of the evidence, right? So if you have a civil case, you want an instruction that very clearly says all that's necessary, if you represent the plaintiff, all that's necessary for the plaintiff to succeed in this case is to establish the proposition that they're saying is more likely true than not true, right? And then maybe a little more elaboration, tip the scales ever so slightly in their favor. So it's very clear as to what it is. Now, if you're the defendant, you're going to look for an instruction that tries to make that a little either harder to understand or make it sound greater than what it is. In order for the plaintiff to succeed in this case, the plaintiff must establish by the fair preponderance of the evidence that they are, in fact, that the defendant did in fact commit negligence, that negligence caused in fact the defendant, the plaintiff harm that occurred on or after such and such a date. And you say, well, geez, that's a lot of things to figure out. But if I'm the defendant, I want to make it harder. But if I'm the plaintiff, I want to state that ever so simple. It even gets more difficult if you think about a jury instruction that would frame reasonable doubt. Because while we all have that pretty clear understanding of preponderance of the evidence standard, because it is a very relatively easy standard to understand, we could look at a bunch of different cases in a bunch of different books, and you would have, you can find numerous jury instructions, legal definitions for what reasonable doubt is. And some would most decidedly favor the prosecution, and others would certainly favor the defendant. Depending on who you represent, it depends on which instruction I would propose and which one I would fight about getting. And that's the same type of thing we do for all of the cases. You have a simple red light violation that occurs as a result of an act. Then there's an accident that flows from it. Your client's been damaged. You want a simple instruction that says that they can use the fact that there was a red light violation, a statutory violation, as some evidence of negligence. Right? That's what jury instructions do, is they go through the law that the jury would have to find in order to find on behalf of your client. The problem in other courts is we don't necessarily know exactly what the instructions will be. Worst case, sometimes till a final conference, which might take place just before closing arguments. For relatively short cases, we don't necessarily get the same amount of time. I think, and the better practice is for all parties to know prior to the case beginning, and so then you will tailor your opening statement and your presentation of evidence and your closing argument around what that instruction is. Now, let's just get to the last part very quickly about how it works then in practice. Okay, so we've tried a case, and it's been a day or 30 days, and we're just about home. You know how people finish up. My guess is somewhere around, for those of you that stay at night, sometime around 10 past 10 tonight, you start futzing around, getting ready to leave, even though that class isn't supposed to be over for a few more minutes. Well, the same thing happens as we all end up knowing we're in the final stage of a trial. But the last thing that happens when that case is getting tried is fundamentally important, which are the jury instructions. And so it's vital that you be vigilant at that point in time and make sure you get the instructions that you asked for or submitted, and object to the ones that you think are inappropriate. Now, oftentimes the court wants to get it to the jury as well. Maybe we want to save what's left of the hour or two today, or we just want to be done with this quickly. So sometimes, while it's a fundamentally important thing, some judges will rush it. And that's where problems can come in as well. I've never really quite understood how you could have a multi-day trial before the judge, where the only thing you really have to worry about is what's going to happen in 3 days, 4 days, or a week from now. Where really, couldn't you be sitting up there half the time and just revising them and working on them so you get it right in a week or 10 days when your time really comes? And you'd be surprised how that's not always the case, and it's sort of, at times, an awkward presentation and doesn't have the clarity you'd want. And then what that means is you have to object when the court has finished the instruction. Oftentimes they will ask you to come back up to the bench. Anyone have any problems with what I just did or what I said? And you know, you don't want to be a pain in the ass either. But, well, frankly, I misstated. You do want to be, okay? And by nature, no one likes to be that jerk that is objecting and seen to be a pain in the ass. But this is what you're paid for, okay? And especially at this point in time in a trial. And part of it is, and judges are at times bullies. And so you've got to hold your ground, Your Honor. I think it's reversible error to not give him the instruction that I propose with respect to the violation of the red light constitutes some evidence of negligence that the jury can consider, and you didn't give that instruction. Or even worse yet, when you say, Your Honor, the instruction you gave, reverse the language with respect to whatever it is, and they will do that. You know how we read sometimes, or we think we're reading, you put one word in front of another. Well, if that's not right with respect to what the law is, it can significantly change what they need to find. And so you've got to tell the court, in essence, to correct the mistake that they made in delivering the instructions. And if you do not, because you're concerned about being the jerk or worried about time and wanting to get done and think, I've done all my work, I didn't faint when I was cross-examining a witness, and I didn't throw up during my closing arguments, all in all, pretty good week of trial, you haven't done your job if you don't finish it correctly, right? And so you've got to hold the line there and make sure they correct it, because one of the first rules is, if you don't object to the instructions given at trial, the likelihood of your being able to take that issue on appeal is very, very low. The fact is, almost always you have to give the trial court a chance to correct their error, and especially when it comes to jury instructions. And see, I would like to be, and again, it's against our nature sometimes to go out and look for additional work, but especially with respect to instructions, I would want to know sooner rather than later how soon the court wants the instructions and how soon they will provide that information to us so that we can properly prepare our presentation of the case. Ideally, we want to know at least before, I want to know at least before the start of trial. And ideally, I'd rather want to know 30 days before the start of trial. Even if I know 90% of it 30 days before the start of trial, I can get comfortable with it all. A lot of times I may not know till trial. In some cases, you won't know till they might have a conference after one of the days of trial and say, okay, let's talk about the instructions I'm going to give tomorrow or the next day or whatever. And that to me is a little sloppy, but that's a practice in a lot of places. We get personnel conference. Go ahead.
Jury trials for civil matters. Aren't juries, I guess, from a psychological perspective, turned off by nitpicky attorneys that constantly object or make these sort of points as to the instructions and end up probably not liking the attorney and then just ruling against them, or just being completely turned off by him? I've
got two anecdotes in that regard, because I always worry about that, because I tend to be the one that's objecting. But there's a couple things that I've learned in that regard, because we've been able, in some jurisdictions, you can talk to the jurors after the case is over. And one rule of thumb, first of all, almost always is they have to like you. If they don't like you, they may well go out of their way to find against you. That's just human nature, right? But I even asked about that, because, and so what they told me is that, how did that affect it? Because the personality, this one trial, a lot of lawyers in the room, a lot of intense personalities, and I really did wonder how that would play out. And what they told me is that, no, we didn't like those attorneys at all. We hoped you guys would win, but if you didn't present us the evidence, we were still prepared to fine for them. And that's virtually verbatim what they said. But that's what they said, is that yard will affect it, but if it's not close, you're not going to get the call anyway. If it's close, I think human nature being what it all is, if we like you and we think you did a good job, if it's close, you'll get the benefit of the doubt. The other thing I asked about, because I tell some of you who have heard the story that I've had evidence with, I went 0 for 13 or 14 one morning with my evidentiary objections. It was a Wednesday morning, because I'll never forget it. And you know what it's like getting up on after 13 overrules to do the 14th one. And so, and by the way, not to be defensive about it, but the judge was wrong on many of the rules. So that's not the first or last time that's going to happen either. I asked them specifically because, see, this was actually a bifurcated trial, so we were going to have a second phase in the same jurisdiction. I needed a better feel for it, because it's not around here, so I needed a better feel for what another jury would think about as well. And I said, when someone objects, what's your reaction to that, especially if the judge denies it? I mean, denies the objection. What were your feelings on it? And they said, and I thought it was very perceptive. This was a smart jury, by the way. They said, well, we figure if you're objecting to something wrong, with what's going on. They didn't see it as you're trying to keep information from them, which I could see, especially when it keeps being denied. They said they didn't see it that way. They figured that there was something that was wrong with what was being done, and you were objecting and you were losing. That's just the way it goes. The other part of that they told me, and this is, you can do this whatever you want with this, because I still think, and I could defend either position on this. They thought, and this judge was very, very rude. They picked up on this. This was very, very old school, really, really rude. He could make seasoned litigators sort of buckle at the knees. He was very, very rude. They said to me, you know, one thing, we didn't understand why, when the judge was like that or overruled your objections, why you thank him for the job that he was being paid to do to begin with. They thought that whole notion of, well, thank you, Your Honor, is kind of outdated and expressed to me that why would you thank him at any rate? But we were together, like, it was an 8-week trial, and it would be clear to anyone, this is not someone after a while you'd be thanking at all. And so it's not necessarily the way you think it. Now, this is just the reaction of one jury, but I think it's kind of telling that some of the things we worry about and obsess about as lawyers, they don't see it that way. And I do think some of it's true that if you're really obnoxious and rude and fresh and have a brusque manner, that's not likely to help you. I tell the trial advocacy students that I teach, I think there's 3 C's in a courtroom that are vital. You need to be clear about what it is you're doing, what you're asking, and what you're saying. You need to be in command of the space, both physically, verbally, and otherwise. And then the last thing is very little to do with being a lawyer. Well, it should have more to do with being a lawyer. It's being courteous. To ask nicely for what you want, to be polite, to be respectful to the court, to the opposing counsel, to the jury. Courtesy goes a long way in our business, and it's sad that it makes you stand out sometimes. But it's pretty basic things if you think about it. Someone who's polite and respectful, we tend to provide them more respect than we would otherwise, and I think juries appreciate it as well. And I think it's something, especially early on, you guys have to guard against, because some of these personas you see are sort of the bully in the courtroom space, and we really don't care for that person, whether it's outside the courtroom or in. And so you've got to be careful with that. I've always admired those lawyers who are really soft-spoken and quiet, and sort of come at you like the choir boy assassin. You might guess that's not really my game. But I try to be, and I think we all should be appropriately respectful. So I don't think, and especially with respect to instructions, you need to make those objections, because if you don't fix it here, you're going to be behind the 8 ball. And so some of those things we think as we start to talk to the jury, it isn't quite as bad as you think. I think the biggest thing for you guys to learn going forward, after you've had evidence and start to think about trial skills, is what I said to begin with. That, you know, judges are going to make incorrect rulings, and you can't, you know, get annoyed and aggravated and have that show, because that's the nature of the beast. You know, those of you that have had evidence struggled with hearsay. Well, trust me, trust me, trust me. Judges do too. You know, judges do too all the time. I tried a case over here in Middlesex Superior. Great judge, well respected, had a complete misunderstanding of the rules of hearsay. He's here now, he can say whatever he said previously. Oh, no, Judge, that's not really the rule at all. But that was the judge's understanding, and that's the way that case was going to be tried. But what you have to do is you've got to protect your record on the important pieces then, that to make sure you keep out, because then you want to preserve your right for appeal. But that's the delicate balance now. I'm preserving my rights for appeal, even though this judge is getting annoyed, because I'm not going to teach him the law in the next 2 or 3 days as I'm doing this case, because he thinks he knows it, and it's clearly wrong. And you got to roll with that, and that's harder. It's 2 things that are harder. One of which is to trust your instincts that you were right as to what the law is, because more likely you're going to say, GD coin, I knew he was wrong about that. And that's the first thing. And the second part of it is, then if you have the confidence that you know what you're doing, it's hard sometimes to respectfully, politely roll with the punches when you're getting rulings that are just clearly, as you know it, wrong. Okay? Anything else on instruction? Go ahead.
I'm thinking about a situation where the judge includes both sides' instructions and they both have written them in a strong way to influence their side.
Yeah.
That's going to totally confuse the jury.
Absolutely. And that's why, and that's right, and so it's not, we just don't object to the ones that, of ours that you don't give. If the onus is wrong, or I make the point just what you said, Your Honor, you can't give both, okay, because both are going to lead to confusion. And that's where the court has to then make the call as to which one. Sometimes, by the way, we might both submit them, and the court say, no, I'm going to give my own. And if it's close enough, you can object. But you know, as you probably learned by now, the law is mostly gray, and so it's not necessarily black or white when we say this is the instruction that must be given. But the fact is that there will be that problem as well. Is, Your Honor, you really can't give both instructions on preponderance of the evidence. It's going to leave a greater confusion. Pick one, and then we'll have to argue about it either here or on appeal. But preponderance of the evidence is one that is pretty easy. And even beyond a reasonable doubt, most judges who have tried cases for a while have their own reasonable doubt instruction. And they're going to give that because they've been protected on appeal before. It's when cases are different from the norm, you know, antitrust cases or things, or even simple, you know, statutory violations that they might not have had, and that type of language, which is more case specific, is where they may end up in greater trouble. But you know, your standard of proof, they should be able to get that pretty easily. You know, the credibility of witnesses, and there's a set instruction on that the jury should get. The one I like with respect to that is that you know, if you disbelieve any portion of a witness's testimony, you are free to disbelieve the entirety of that witness's testimony, because if you can't trust them about one thing, then you have the ability to not trust them about anything, especially if we think we've made some inroads on cross with some of those witnesses.
You pretty much answered the question, I think, but because my question was, aren't there certain, at this point in the history of law, certain like standard instructions that you'd really have a hard time supporting an argument not to use?
Well,
like particularly preponderance of the evidence or proof beyond a reasonable doubt. I mean, it seems to me it would be, how do you make an argument, or how do you support an argument to change instructions? Or
well,
maybe
it's not because it's not really changed. We could go right now, and it wouldn't take long. If we went downstairs and went online, we could probably fairly quickly. And again, preponderance is a pretty standard one. We could probably find 3 variations of that in the jury instruction pretty quickly. And preponderance is easy. Beyond a reasonable doubt, we're going to find a lot more variations. But what you do, and this is why the judge more than likely is going to go with his or her own, is that the Supreme Court at some point has said, no, this instruction is fine for beyond a reasonable doubt. Well, that's the one I'm going to give, and I don't care then what you guys might propose, because I know this one, until the Supreme Court says otherwise, this one's going to pass muster on appeal.
Yeah,
and that's
my point. Is I would think that judges would lean towards whatever has been the acceptable standard, because you're going to try and slant, you know, the instructions to your client. Your opponent is going to try and slant the instructions to theirs, and the judges know what's going on, right? I mean, so aren't they going to pick an instruction that's already proved? I mean, I can't imagine at this point in history that there are many different instructions.
You're assuming, how are you assuming they get to that instruction? Because here's the other part of this, that we don't, I don't think we readily appreciate. They tried A and B with the deadly weapon the day before. That case is over. It might have finished at 4 o'clock that afternoon. And the clerk is calling whoever's next on the list to be here by 8:30 tomorrow to get ready to impanel the next jury. With any luck, it usually is another criminal case, so at least we don't have to change types of cases we hear. It's not always going to be that way. And the court may or may not open that file until sometime 8:30 that morning. they don't have the prep time like we get, right? We focus on a case for a couple of years. That judge might have just transferred in from one county to the next the day before, and you've got an incredible education job in just a brief period of time. So they do have books, and that's why they rely on sort of the judge's book for major instructions. But in any given case, listen, let's take one that should be as settled, but obviously, at least in the court of public opinion, it's not that settled right now. This is Trayvon Martin and the ability to, whether it's stand your ground, self-defense, whatever you want to call it, but I'm not sure a standard stand your ground self-defense instruction is going to cover this one because, well, at least in part, I mean, so you can follow someone and then still invoke that poor me, because it's something, just psychologically, something doesn't seem quite right about that to me. And so my guess is that we may say, yeah, there's a standard self-defense, or down there, stand your ground instruction, but it's got to be tweaked and tailored to what we've got there. And certainly, depending on who you represent, if you're the government or the defendant, you're not willing to accept just a simple, boxed instruction in that regard. And so that's why it becomes more complicated. And where the risk is that the court simply doesn't have a lot of time like we have to prepare. That's why they oftentimes will tend to rely on the lawyers.
See, I would think that would speak more to the evidence you present in your opening and closing arguments, not so much the instruction on what exactly the statute is. I guess any statute can be interpreted differently, and that would change the instructions, right? I mean,
yeah. Well, even the instruction on the statute, depending on who
right.
wants to slant it their way, that's a different instruction, and that's right. And the problem is that's why oftentimes the instruction doesn't come until the end, so the court has a little time to get a feel for the case. But I got to know I got to know what that is from the opening, because if I don't set forward the prima facie case in my opening, I can be directed out on my opening because of the failure to establish the elements of the case, and so it can become a bigger problem. If you do your work in prep time, knowing what you expect to get, for 90% of it, you should be fine. But if you don't protect it here, you're out. And the other thing that's a little twisted about all of it is you put all this time into everything else. You spent 2 years working on a case, and you got a lot of hours in. This is fundamentally important, and oftentimes we don't pay as much attention till we're closer to the end game. And I'm suggesting that you think about doing it earlier on than even I do it, and I think it would help your advocacy and your discovery and everything else. Yep.
How do you protect yourself on appeal, before appeal on instructions? Is it just per se you do it after the fact, you don't object anywhere, or is that?
I submit proposed instructions, first of all. I object to her proposed instructions that I think are in error. When the court has what they call a charging conference, I made clear in the record that I don't think her instructions number 1, 8, 9, 12, 15, 18, whatever they are, because they usually would be separately numbered, are appropriate to give, and in fact they're not the current state of the law. I told you I got sued in Rhode Island, right? The plaintiff's lawyer wanted an instruction, I'm told, at trial on the last clear chance doctrine. Now, I'm not licensed in Rhode Island, but I don't think last clear chance is a doctrine in many jurisdictions, period, anymore. And so he wants an instruction on last clear chance, but as it turns out, it's not the state of the law in Rhode Island either. And so the court rejects that instruction, and they knew, but it didn't know until after the trial started. But hadn't even requested it till after the trial started. But so you got to object, and then when they're given, or if yours are not given, you've got to again put into the record, the stenographic record of the tape, if that's how it's being maintained, what the problems are with those instructions and what the court's error is. And if you stand your ground, the court may well correct it. And if I stand my ground and she doesn't, and because that's more likely what's going to happen, the court's going to look at Fiona and say, you have an objection to that? Or what do you think? If she says nothing, then now it's on her, because the court can give my instruction without worrying that, because she hasn't properly protected her record. So it all comes down really to a game of chicken in the last couple minutes of the trial, and that's what I'm trying to tell you. You got to be prepared for, because you need to be confident and comfortable about it, and you need to know the law well, because that is the last thing they hear. And it's a shame to have spent tons of time on the case and not get the right questions to the jury, and that's again where you've got to be vigilant. You got to think of, and questions to the jury simply what's going to be presented to the jury in order to find either on behalf of your client or for the other side. So how that's phrased, how that's worded, is fundamentally important. I want the question to be so easy so that they can absolutely say, yes, Mike wins, right? And that's really a matter of wording. And so if I get my questions and you don't get yours, I win, you lose. And I can leave at that conference knowing the price of poker just went up, because I got my questions and you didn't get yours, and you should have been far better prepared for that whole conference. Because if the instructions are the last word the jury hears, really the last word is when they open up the verdict form and have to start to fill out the questions. Now someone's speaking to them while they're deliberating, and I hope that's me through my questions that I got at the conference. Okay? Anything else on that? So that's why instructions, I wish we spent more time on them in law school as well, because it's both a process and substantive part of it that, at least with respect to trial work, ultimately become fundamentally important, and it really dictates whether we win or lose. Well, let's talk a little more about our cases, because the last we spoke, you were going to try and value the baseball that I caught at Fenway Park. I have another one actually I brought up today to you. This is signed by Tony La Russa. And I got this at spring training. I couldn't find the picture today. I know it's in my office, but these are my two boys. And when they were little, they were a lot cuter then. No, really, it's a great picture. But I have them with a picture with Tony La Russa while Tony is signing the ball. And then we went back a number of years later to a different spring training, and I took that picture. What's this baseball with? Tony La Russa. You know what Tony La Russa's claim to fame was, by the way? At one time, well, because he no longer manages, he was the only manager in Major League Baseball who was a lawyer. So what's this baseball worth? Because that was a really good day, and I'll tell you, I wouldn't sell this baseball either. So, how do you value that if Freddie should steal it out of my office?
$3.
$3? Now, how do you value unique items?
Someone's willing to pay for it.
What someone is willing to pay for it. Anyone?
Well, a reasonably informed baseball fan that knows the background and history of Major League Baseball.
Well, what if it's Fiona? She doesn't know anything about it, but she's willing to pay me $10 grand.
Did you take almost like the Blue Book approach to it and see what other Tony La Russa signed baseballs have gone for?
What about that? Is there? Do we think we can find some type of market for Tony La Russa signed baseballs? Sure, right? There probably is. Sports World over in Everett there, I think, as you went in, they have tons of baseballs signed. So Tony La Russa may not be Babe Ruth or one of those.
His autograph probably has some value.
Over and above the value of the ball.
Yeah, to these collectors, yeah.
And so it would be easier to establish a market value for that ball than the one I caught at Fenway Park? Because there is a market. We can look at autographed balls.
And you've authenticated.
Right? I have a picture of him signing it, and you can actually still see, it was a long time ago now, they were little, but you can see it's clearly Tony La Russa still. And I do have a picture of him signing that ball. And I have a picture of the boys with him while he's signing the ball. But see, it was such a great day, I wouldn't sell it. So if you said, well, Freddie took it, how much would you have sold it for, Mr. Klein? I would not have parted with it for $10,000. So is it worth $10,000? Because I bet the market, if we went online, is going to be a lot less than 10,000 for, because he seemed kind of generous with his autograph, frankly. Some people are not, he was. So 10,000 or whatever we find online, just like we would do with that 2007 Jeep. Baseballs signed by Tony La Russa range from $150 to $300. If you get it for $150, that's it, or we'll give you an average of some sort, but you're not getting anything beyond $350. Is that right? Because there's a market? So your own, because you did this Campins versus Compels case, and he put some value on it. Your own sense of what it's worth is meaningless? Doesn't help to establish a value? Because see, I have rosary beads with me too. What are you doing? And I wouldn't sell these for anything, but if you look, they wouldn't, and they're not, physically, they're not worth much. Go ahead.
Well, the case says it's improper to consider evidence as to what someone wouldn't sell it for. So, I mean, you can't consider, like, I would sell this for $10,000.
That doesn't help establish market.
No.
And in order to establish market, others must share, you must be able to establish that others would share the valuation in some sort. No? Are there items of value you have that, if lost, you would be seriously damaged beyond financially? Things your grandmother gave you, maybe your parents gave you, brother or sister, items of some personal important value to you. And so tell me what happens if they're destroyed. I mean, the 2007 Jeep, we've got that covered, right? Your real estate, we've sort of got it covered. But your baseball, your religious artifacts, things like that, go ahead, Bob.
I think it goes back to like the sentimental value argument that they said, even if it's mawkishly emotional, I mean, that doesn't matter at all if it's an unreasonable attachment to this thing that can't count towards anything. It has to be something that's, like you said, a grandmother's ring. Like, I feel like anyone would be, like, that's the kind of sentimental value you can attach to something.
Well, tell me how we would do that, because I think that was also one of the things I left you, is your grandmother's diamond ring, or great-grandmother's is my recollection. Is that worth more than the price of the setting in the stone? The fact that your great-grandmother wore it? Or is that just no? We figure out what the diamond was, we figure out what the setting was, and we'll even get you an antique ring. But that's it. Is it? That's it? The fact that your great-grandmother and maybe your grandmother and maybe your mother all wore that ring that give you the connection through the ages, that has no monetary value.
It does. But what this court talked about, that you have to view it in the realm of sensibility. That you can't, that there is sentimental value attached, and that the court will look at that, but it can't be so totally unrealistic.
Go ahead.
I would also agree with Karen that the court has a wide range of of determining fairness and equity. They're going to take factors such as actual cost of it, but they also take it as a less prosaic nature, such as the proposed use for different things, the feelings of the owner, the cost into other elements that might not always that you can put an exact cost on it, but sentimental value may play in. But like Karen said, it's not going to be a huge factor in it, and it's a case-by-case basis.
So wait a minute though, so let's just slow. So I could get some value over and above the sum of its parts, as long as I don't get pickish. Is that true? So the ring to replace, we'll say $5,000, just on the sum of its parts. But since it was your grandmother's, we're going to give you, we agree, your great-grandmother's, and we agree that others would share that there's some value over and above the parts that we're going to give you a 50% kicker. Since it was your great-grandmother's, $7,500 is the value of what you lost. Could you make that argument? No. Would you think within the law as contained in this case that we have some chance of succeeding on that? Because they did, as Geneva pointed out the other day, they gave him something for the value over and above the sum of its parts. But you got to be careful how far beyond that you go, right?
Probably depends on what the judge thinks of his grandmother.
Well, it may, and it may well think what the jurors who are going to have to place a value on it does as well, right? Because it doesn't mean I don't have an argument or I might not be successful. Part of it does depend on who's going to be listening to it. And it does talk about others have to have similar feelings about the sort of the blood, sweat, and tears, the value, that somehow it's got to be shared by more than just you, because that's just that mawkish sentiment that we finally can't get. Here, they said on his ring, it was $750 per ring. The court's award of $1,000 apiece could only have been improperly based on speculation. At the end of the day, they're a little high here, but a little high doesn't mean that you don't have some ability to try and capture some of it. But you've got to be careful, because if the valuation is based purely on sentiment, you may be out. What if we could show that others would share the appreciation and the value of it? My baseball that I caught at Fenway Park, I think, had a market value of $12. You could go out and get another Major League Baseball with the same stamps on it for $12. I think, though, it would be worth at least $500. Could I get $500? How many of you tried to catch a baseball and never did? How many baseball games have you gone and failed? Why do half a dozen to a dozen people go and try to catch that baseball when it's coming? At the risk of life and limb. Go ahead.
Well, I haven't tried to catch a baseball, but in regards to what you were saying, about the other people enjoying it as well.
Yep.
They were saying here that they took in the factor that it was a recognition of, national statute, and so others were, I guess, enjoying it because it was a national symbol. Like, he won it, and it was almost nationally enjoyed, that achievement. Whereas your baseball, I don't know how that would compare with here. They added.
But my baseball, Alina, doesn't mean that others don't have a similar baseball or artifact that they would see similarly.
But I understand this as it would have to be that baseball that's nationally recognized. Like, that is the enjoyment by everyone, not everyone else.
I thought they were saying the achievement, winning this major race. Because it can't be just confined to that race, right? That trophy, or could be, I guess.
I thought that it.
I'm not sure I'm not saying you're wrong. I'm just asking, because that's kind of narrow. That's a narrow rule of law. Then, if we could broaden it, then we could say, no, there are other things that fall within that as well. If you can, I mean, is a market value means that others would share that valuation, right? So, can't we make that argument?
But it's a little harder.
It is a little harder because this is my baseball.
No, it's harder to get the ring, I think, than to catch the baseball. Isn't that weight as well? You have to go through.
Oh, sure. Okay, that's fair enough.
Okay. So I think that the court will take that into consideration when they're adding the above the market value amount.
I don't disagree with that. I just want to know when your client says, so for my grandmother's picture and my grandmother's table and that wedding ring, that's it? And it does, I'm hearing, well, we got a little play, but not a lot. What about my dog? We have a new dog. He's not that new anymore. He's 2 years old. He's a doll. Just a dog? I mean, he's a dog, no matter what. He likes to be held at night too. He does. He doesn't understand who he is. He is actually a white miniature schnauzer. He's not that miniature, but he's a white schnauzer, which is a little unusual too. But he's seriously, he will sit on your lap all night and comes down to greet me every time I come home. Every time. especially if I've been away. He's like howling in the basement as I'm parking the car. He's worth more than what we paid for him, isn't he? Or not? Because you read the last case of the sequence tonight, right? And I don't quite get the attraction to sheep, I'll say that already. but our dogs and cats, I think, fall into different categories. Is he worth just what you paid, less depreciation? I mean, is that it? Is that it? Because, I mean, this is Professor Sullivan's bailiwick, as you may know. But it does, I mean, companion animals are a little different, aren't they? Or not in the law season? Because with the last case, they could have got the value of the sheep itself, but the commercial value. Then they were simply saying, no, we're not even going to put in evidence of that. We want loss of companionship. We want damages like this was our child. So what do I get for my dog? Scout. What do you think?
Nothing in the state of Massachusetts. You don't get loss of use and enjoyment and
so
emotional distress.
It's a commercial product. Is that about right? A depreciated commercial product. He's 2 years old. We paid $800 for him. I think useful life would be about 12 years. So 1/6 minus 800, whatever that is. That's what I get. Fred says no. What do you got?
$3 million.
Oh, you got Freddie shares a value over and above the cost. Well, and by the way, when we're talking about others would share the value, I think this would not be a hard sell, again, depending on who we get, that your pet, your companion animal, is worth more than whatever it is you paid for them. So I just want to know what you're going to tell me. Go ahead.
I think it's all, well, I'm basing this on Campins, but the other case was a different situation where they should have put in the market value of the sheep.
But the market, John, the market value, though, just so we're clear, would be whatever it would cost to go out and get another sheep and put them in the farm, right?
Yeah.
So, like,
Yeah. So, but I think Campin says, it's like saying this is going to be a factor. Sentimental value is going to be a factor, and you can also use mental suffering as a factor, and you can use, so it's almost is like suggesting that the more ways that you can value it, the more of a chance you'll have for those extra damages.
But didn't the court at the end of the day in Campins and in Kresnecki say, well, at the end of the day, it's an item, what you lost, and okay, you're sad and you're this and that, but don't we think we're adding on to the value of what you've lost here? You get the commercial value, if there is some, and if not, we might give you a little bit of a kicker for some of it, as long as you're going to be able to go beyond it. But you're really, for the most part, going to be limited to what the value is. They even, in one of them here, they wouldn't even give them the medical expenses. And is that right too, by the way? So someone runs over my dog with their car. The dog is worth $800. He now needs a $4,000 surgery. And they can say, no, he's not worth $4,000. You want to do that, you do it. But the most you get is $800 because that's what the price of the dog was. Is that true too?
Probably, but if you witness them running over the dog, or you picked, then you
Yeah, that's what it says.
Can I? I can get emotional distress for the injury
It's
to my
like
dog?
the spatial and temporal
I'm
proximity.
saying no.
I think they said that.
No, it says
No,
the
they said
spatial
they-
and
they said
temporal
that-
proximity upon plaintiffs. It's been limited.
Okay.
Who witnessed the injury or come upon the injured party at the scene of injury immediately after the.
But the party has to be, the party has to be a person, right? Someone
Yeah.
within that protected relationship. And your sheep and scout is not. Is that right?
Yeah, I think the Massachusetts case was a family was walking their dog, and they were walking it on the side of the road, and then it got hit. So they were able to apply for emotional distress because they witnessed it, but they only got for the amount for the dog.
But I'm not sure you got to the amount of the dog. I think you can get the emotional distress inflicted on you, perhaps. But the fact is, you still lost the animal. There were a couple of cases in Boston, the Charlestown area, where the walking the dog and they stepped on hot spots. The dog died right in front of them. And the settlements were large, but I'm not so sure the law supports the value other than wanting to keep it quieter. If you look at this, the Krasnecki versus Meffin case, call it a companion animal all you want, but at the end of the day, you're going to get the value of the animal and not a lot more. Let's take a look at this Griffin's case, because I think Griffin is, in General Motors, is the type of case, if you're going to be doing any form of personal injury, that you're going to have to start to think about as to how you start to prove your losses in these types of cases. And there's a couple of interesting things going on. By the way, there's a couple of very interesting things going on in here from the standpoint of procedure. There's we saw jury instructions, we have summary judgment, we have some directed verdicts and the like. And I don't mean to pass those over quickly, because I expect you to be able to deal with all those issues and talk about those issues, certainly in the final in this course. So when you see that stuff and you see these instructions, I hope you start to think about them again, because those issues are important as we start to wind our way in figuring out what remedies are, because it's both procedure and substance that becomes involved as to whether we win or lose or not. So I want you to think about some of the issues, procedural issues that developed in these cases with respect to directed verdicts and jury instructions and the like as well. And it talks a little in this case about the charge to the jury, and that's the instructions. If you look at it here, that's listed on page 364. And they have some interesting evidentiary tests. And again, can I ask how many of you have had evidence yet? Okay, so most of you have, and I know not everyone has it. But if you look here, again, from the standpoint of evidence, they talk about whether the test conditions were sufficiently similar, as those of you that have had evidence understand recreations and the like are subject to a sufficiently similar standard, such that they will aid the jury's understanding. So that's on page 365 where they talk about that. And I do think as you read these cases, it is important to start to see how a whole bunch of things tie together on this. Different parts of courses you've taken. So let's talk a little bit about the details of this case, because I think it's important, and it's important for you guys to start to see how you establish that. The judge instructed the jury, it says on page 366, that she's entitled to her past and future impaired earning capacity. And then the defendant objected to the instruction, and the judge's refusal to instruct that there was no evidence of future impairment. And let's, I think honestly, the evidence in part is a little light in that regard. But what we have here is someone who's been very severely burned, and a jury awards her $1 million in damages, and then you get statutory interest as well on any judgment. And in some cases, especially in the older cases, as you see this statutory amount, it was really high, because the longer it takes to get to trial, that interest keeps adding on to the ultimate award that'll come. And so in days gone by, the interest was oftentimes a huge addition to a lot of these judgments, because it might have taken as many as 5 years for that case to get to trial. I've said to some of you before, you would not want me on a burn injury jury, because I would tend to award an awful lot of money. That's, I think, both from the standpoint of pain and both physical and mental, that's a significant burden to carry. But here, and I think that's what the defendant's a little worried about here as well, is where's the proof that supports that award. And so if we look at a couple of the problems here. When she does go back to work, she's actually making more money than she did before the claim, right? Before the injury. Well, how how does that support then future lost earning capacity? I mean, if you've lost wages in the future, as a general matter, we would see a reduction. Right? Sometimes people are permanently disabled, they can't go back to work at all. Well, that's not going to be that difficult to be able to establish that you're making $500 a week before the injury, you are unable to work now, your damages going forward are $500 a week times whatever your life expectancy / work expectancy was. That's pretty straightforward, right? But here we've got someone who's making more money than when she went back, than when she did before. How do you show loss of function? Because that's the other thing. Permanent disability is a relatively easy thing to be able to calculate the damages on. But here the doctor testifies she's got a loss of function of 45% in her left hand, 25% in her right, and 30% in her knee joints. So does that just require an expert assessment as to what the loss of function is? She used to be able to raise her arm to here, and now she can only raise it to here. I mean, is that the way that evidence may well have to come in, is through expert testimony? Someone who's examined her and has sufficient qualifications that they can testify to what that loss of function is? And tell me how we get to any assessment on impaired earning capacity, because the judge said to counsel, this is the language, and I worry a little bit about this, although I don't tend to bleed for General Motors either. It says, I think it is susceptible of common knowledge that with the massive scars that she has, that her future opportunities for employment are going to be impaired. If I were the defendant, I'd worry about that instruction. The evidence indicates she has zero present loss of earning capacity. In fact, she's making more. But logically, that also, I mean, we know, personally we know, that doesn't mean she hasn't been damaged. Or is it just she doesn't have that item of damage? She's got scarring, she's got medical bills, she's got a lot of other things, but she may not have future lost earnings. And if she doesn't have future lost earnings, then this number has to be reduced. Do you think it is? Do you think she does have lost earnings? Why? I don't disagree with you. How are you going to articulate why?
She's probably, one thing is she's afraid to go to work. People look at her differently. She might be getting good money for her job right now, but over the long run, she might not work as long as she would have.
And I don't disagree with that, but shouldn't there be evidence introduced into the record that supports that?
There is evidence, because
What's the evidence?
The evidence is that she doesn't have the same mobility. She doesn't have the same functions of her arms, of her knees. Those are real issues, and those are debilitating issues. Her
But
knees aren't
in
going
fairness, though, Karen, they're not presently debilitating, right?
But-
She's going to work on a regular basis, and she's earning more money than she did before. Where's the evidence that it's to the point where she will not be able to do that?
I think that you have to, that when you have the expert testify who has had other patients with similar debilitating injuries, what the outcomes have been, and that's the way that you could assess it.
Well, is it, go ahead.
But for the actions of the defendant, her potential is not what it would have been free and clear without these impairments.
I don't disagree with that either, but I'm looking for proof now.
I don't think you need it.
Well, what do you mean you don't need it? We saw the cases we've bring up to now, and certainly when I asked you about my rosary beads and my baseball, you would tell me that the damages can't rest on your speculation or sentimentality. We could say pity, right? I mean, none of us would want to be in this woman's position under any circumstances, and we would all be very generous if we were sitting on the jury. I have no doubt about that. Well, where's the proof? Yeah, but so what proof are we talking about? The best the language gets, I think, is it says, in his opinion, there was a probability of the development of a traumatic form of arthritis in some of all of these joints. And I'm almost willing to accept that. I think that would seem logical too, right? But the reason we're in law school is we couldn't get into medical school. So what the hell do we know? Alina?
I was actually going to say that the only thing you can rely on here is the expert testimony and the language you just read. But also that's not really strong enough, I think, because it is just a probability. But really, what else do you have to go on? It is pretty obvious, though, that she's impaired now, and it is going to be more difficult to possibly get another job. But really,
But that's just from our common sense, right? From our own sense of bias and the like. No, which, I am dismissing, but I also recognize, and I do think it's true, but I tend to be a lawyer, right? And I'm looking for the evidence, and I'm thinking it's a little scant, and I don't want to overturn it either. Go ahead.
Well, the judge in, I'm not sure if this is the case you're talking
You speak up a little lot.
Sorry, the General Motors case. The judge said that the assessment of damages for potential earning capacity is going to have to rest on the common knowledge of the jury.
That's what he said. I agree with you. So you think that that's fair?
I mean, how else? You can't look into the future. I mean, that's the only
Well,
thing.
we do look into the future
I
all
was
the
just
time.
going to say, regarding that same point, can it be calculated that her usage and the longevity of her arms and legs, that means that she would have to retire sooner? Could we say that? Could that be proved that she would?
Can we say that? I mean, who the
Yeah.
hell are we? This is
Yeah,
what
that's what
about.
I would try to argue. I'd say that she's not going to have the same longevity that she would, so therefore she'd have to retire sooner.
Okay, but listen, and I'm willing to accept the argument. But trials aren't just argument, right? They're the time to present evidence. So where's the evidence that supports it? Because the court does say common sense, and we're all agreeing. We're all agreeing with the point. But as lawyers, where is the evidence? I mean, actually, I think I know who tried this case. And I'm not trying to be super critical, but a better job could have been done. Paul Sugarman was a great lawyer, great lawyer. He used to be the Dean of Suffolk as well. But
doesn't that evidentiary proof go back to what Karen said about the usage that's proven that she's going to have that less usage of her arms and legs?
Where's he say? Oh, just the simple reduction, the loss of function, 45% or left. Which, by the way, that's a lot, right? That's nearly half.
And then that, coupled with the common sense of the jury, could obviously, determine that she's going to have to retire early, or therefore not have full usage, or maybe possibly get tired easier. So there's a.
And thank God for the low standard of proof that all we got to do is get to more likely than not. No, because it's close, right? I mean, did you? Yes, go ahead, Fiona.
I just wanted to say that the evidence is a bit to myself. Seeing her sitting there, looking at all the scars on her, thinking about the experience that she has been through. And when you compare and evaluate damages to a person, or like the baseball bat being lost, I mean, you cannot compare the two. It's totally different. And the human life will be held to a higher standard than the loss of a baseball bat or a baseball.
Would you remember, Fiona, when we did evidence cases, and it may be a completely different, and it is a different one now as I work my own way through it. We said in the Almeida case that you couldn't display a child to the jury because that would simply, in order to determine parentage, because that would simply evoke sympathy for the child. But let's be honest here, that's partly why we want this plaintiff to be before the jury, because I don't want to see that, and I know I'm going to feel incredibly sympathetic, but I thought that's what we're supposed to be careful about in our trials, because there isn't a lot of evidence that supports what she said, other than her physical appearance. But that's enough. Go ahead.
And as her attorney, I'm surprised that he didn't counsel her not to go back to work. Because then, I mean, obviously, this woman, it's ironic that she could have
Yes.
been at a disadvantage because of the kind of person she obviously was.
And that's an excellent point, and this is where the problem comes in, right? Because she probably wanted to go back to work. She may well have needed to go back to work, and defendants play on that as well, right? That's part of the notion about dragging it out forever, sooner or later they got to buckle under because you've got bills to pay, or you just simply want to eat. And so at some point she probably doesn't have a choice but to go back. And then when you say, well, you're back, and then you make the argument, well, she's back to work, she's making more money. Thank God, what a great outcome. But she's got this enormous burden that she's got to carry. But it does help the defendant under those circumstances.
Can you give that kind of advice to your client?
To what?
Don't go back. It's almost like fabricating damages.
That's the problem. Well, let me ask you what the instruction.
Or how about you know that they don't need to see a psychiatrist, and you suggest it, but they're doing fine. But you say, well, if you want to get emotional distress, you better start seeing.
Well, is that what you say? Is there a difference between saying that?
I mean, I don't know.
No, is there a difference between saying that and saying your case would be strengthened
Right.
if you didn't go back to work? You should go back to work when you're ready. You should understand, though, it will affect how much you're likely to recover from the defendant if you're able, because if you're able to go back to work, that would tend to reduce your ability to recover for loss of earnings. I mean,
But you're going to ask her to go testify that she can't go back to work because of these injuries, yet you've told her the only reason she shouldn't go back.
that's how I didn't say the only reason she shouldn't. All I did was explain the law. No, I'm not trying to be. Well, first, let me ask you that. Don't you have an obligation to explain the law to them? And that's because I think you both raise very delicate questions here that legitimately are things we get extraordinarily criticized for. Your client's entitled to know if they, if they ask you, should I go back? I think you have an obligation to tell them what happens with their case if they should go back. It's not your decision whether they go back, but I think they should be making an informed decision. And frankly, I agree with you. I would not tell you not to go back or go back. That's really a personal choice or a choice between you and your doctor. What I can tell you is what happens with the case. And obviously, and I would also go even beyond that and tell you that you do have an obligation to mitigate your damages to the extent you can work and offset that, you should, so if you're able to. Recognize, however, if you do, that's going to benefit the defendant more than it might benefit your ultimate recovery. I think that's a fair way to do it without trying to be, too slick about it. But I also think you do have an obligation to tell them how this probably negatively affects the case. And, some of them are going to say, so should I go back or not, right? And it's not my call, and it's got to be that clear because listen, let's be honest with you. If I'm on the other side and I'm deposing a client, I'm going to want to know why you didn't go back to work. Doctor says here you went back to work. Why didn't you go back to work? And if that gets tough going, it's going to be, Freddie told me not to.
Well, my attorney told me it would hurt my case. That's what I mean.
Yeah. Well, and listen, that's what you have to hear in your ears when you're having this conversation. What's this look like in paper? Because you obviously have an obligation to your client, but you also have an obligation to yourself to not act inappropriately or unethically. And here's the problem. It's even a bigger problem. It's not always what we say necessarily. It's what people hear we say. And we sit here with a group of lawyers, and the language we use is often much more precise. But people, and sometimes a lot of clients especially, hear precisely what they want to hear. And that's a big problem too. He told me not to go to work. No, I never, ever said that. But here's the problem. You can't really even go down that road of I never said this, he said that, because if we are, now we're opening up the whole privilege area, and we got bigger problems than that as well. So that's why it's always better to err on the side of being incredibly honest. But I do think you have an obligation to tell them. I've told you that story. I had a client say one time, she was in an accident. It wasn't that big a deal, but the doctor prescribed her pain medications. She wanted to know from me, should I take them? I said, all right. I'm not your doctor. You should take them if you think you need them. Well, I don't think I'm even going to fill it. Will that hurt my case? Well, if you fill it and you need them, you can take them. And obviously, that's some evidence of that you suffered some pain as a result of it. Well, my family, feels that we should be hardy people, not go down that road. I said, well, that's fine, you know, it's your call at the end of the day, but you have to understand the law would allow you to recover for pain and suffering, and what is going to happen at some point is we're going to examine what evidence there is that you were in pain or suffering. And somehow she had in her head that this would be greater evidence of pain and suffering by not filling the prescription of medication. No, well, because she would be suffering more. But again, then okay, now let's talk about you have an obligation to mitigate your damages as well. So, and you talk about it as a lawyer, but again, part of it you have to be worried about is what people hear. But you really need to be explicit and clear with a lot of folks because they hear, oftentimes they hear what they want, and that's very dangerous because you have to be even clearer then with that concern. And trust me, I've done this for a long time. You need to be that clear because I've heard people around here tell me. Someone came the other day and said, "Oh no, Professor Malagudi told me this was it." I said, "There is no way he would ever have said that. There's just no way. I've worked with him for too long." They said, "No, he said just that." I said, "Okay, I'll talk to him, but I don't think he said it." And of course, I talked to him and said, "I never would have said that," just like that. And so, but I don't think it was a deliberate lie. I think it's what they heard, and that's what we have to be careful about. A couple other things I want you to look at in these articles, because there's an article on proving partial loss of earning capacity as well. It talks about the VA. I also think this article on 10 mistakes that justice see attorneys make. And by the way, these are from the American Association for Justice magazine that you can belong to annually, AAJ, American Association for Justice. I think it's a $15 annual fee. They have tremendous articles that come out, it's at least quarterly, along these lines, which really help to give you a lot of practical advice about how to practice and to work as a lawyer. And I think this article is very important with the 10 mistakes they see, because especially early on, I think it's difficult to figure out what the value of it is and how you do this negotiation. And I think it's imperative, especially one of them says not seeking colleagues' advice. I still seek colleagues' advice. You know, Peter's one I'll oftentimes go to for a reality check when I think I'm gone too far down one road or not going far enough, and he does the same. And there should be people that you trust just to get a reality check. I get calls from graduates all the time asking about this or that, what do you think? And you need to have people that every now and then when you think you've got problems or you're afraid, whatever it is, that you have the ability to get that, does this make sense to you or is this bad? Someone called me the other day, and it was a very good question actually, and I thought, as we talked, he's from Connecticut, as we talked, it's probably okay, but then his best question was, and he's a young lawyer, but it was an excellent question. He said, "Okay, Professor, but to you, does it pass the smell test?" And I said, "No, it doesn't." And that's the more telling question is, okay, you might be able to get away with it. If it smells bad, then why would you even go further down that road? No one should, but it was a very, very smart question. Because we can talk about, can you do this, can you do that, what are the problems with it, I do this, X, Y, or Z. But at the end of the day, if it's likely to be problematic, and it's likely to put you in a bad light, then you guys have worked too hard to get into that trouble to begin with. And on that basis, we disposed of it once we realized, no, it doesn't pass the smell test, and for that reason, you can't do it. And so he actually, working it through, he came to his own decision, which a lot of times I think you will. And so read the articles, because I think they're helpful, and I think, and also you should think about AAJ has value in these magazines. And the last thing is the notion that the gender bias still exists with a lot of these economic damage cases. And so that you have to factor into your thinking a little bit too. Yeah?
Dean Cohen, we just got the final schedule, so May 9th, 6 o'clock for this class, that's on point, yep?
Yep, that's the only exam scheduled for that day because we have 40 people online, so there should be no conflicts.
Okay.
Right? And yeah, 6 o'clock simply because we have both Dane and students taking it online as well, so there's no conflicts that way. Okay? And it'll be what, 2:04? Or it should say?
2:07, I thought it said.
No, it's not gonna be there. It should be, it's 2:04, it's in a big room so you can spread out. It's the only exam that day, so we'll have the whole second floor. We're not gonna do it at 2:07. That's this room?
Yeah,
No, that's what we
That's what
did.
it said on there.
That's my bad. That's what we did, is we try to keep them in the same room, but you've got another 40 people coming, so, be a little hard. Yeah.
It just said 2:07 on that thing, all right?
Oh, DA shot.
And you're
Okay,
wrong.
all right. When did you have DA? DA will take his given. How many people in real estate?